Hi, I'm Eric Pros, founding partner of Nextera Legal, and this series is called Historical Mishaps, where we discuss legal failures that had detrimental effects on business and real estate deals. Let's get into the story. Imagine co-owning one of the most iconic buildings in New York City, a landmark, a piece of history, a property worth $250 million. Now imagine you can't do a single thing with it. You can't lease it, you can't renovate it, and you certainly can't sell it. And it's not because of the economy or the market. No, it's because you and your partners can't agree on how to proceed. And your agreement with your partners gives every owner a veto. Well, that's exactly what happened to the Flatiron Building, one of Manhattan's most recognizable skyscrapers. And it sat completely vacant for years while the ownership fought it out in court. Today, we're breaking down how this happened, why it happened, and what every real estate investor and business owner can learn from it. Because the lessons here are not just for legacy property owners. They apply to any deal where you have partners. Let's begin with the ownership structure itself, because this is where the problem is baked in from the start. The Flatiron Building was held under what's called a tenancy-in-common, or TIC. 5 owners held the building through 5 separate LLCs. 4 of those LLCs, GFP Real Estate, Newmark, the Sargente Group, and ABS Real Estate Partners collectively held 75% of the building. The 5th owner, Nathan Silverstein, held the remaining 25%. Now here's the catch and the most important part for this video. Under this TIC, it didn't matter that 4 partners controlled 3/4 of the building. Every owner had an effective veto over major decisions, and there were no deadlock provisions. Leasing the building, unanimous consent required. Renovation, unanimous consent required. Refinancing, unanimous consent required. One owner holding just 25% could stop everything. And that's exactly what happened. For years, the Flatiron Building had one anchor tenant, Macmillan Publishers. They occupied essentially the entire tower. Then in 2017, they announced they were leaving. And by 2019, the building was completely vacant. Now the partners had to agree on what to do next. And that's where things went off the rails. The majority owners, GFP, Newmark, Sargente, and ABS, wanted to do a significant renovation, about $100 million in upgrades to modernize the building and hopefully attract new tenants. Silverstein didn't agree. He also alleged that the majority owners had mismanaged the leasing process and that they tried to lock the building into a below-market lease with a co-working startup that the managing agent, Newmark, had a financial stake in. When that deal fell through, Silverstein proposed something that made the other owners furious: physically dividing the building, carving the Flatiron into 5 separate properties. A member of GFP called that idea preposterous. He wrote that it boggles the mind to suggest you could physically divide an iconic triangular landmark into 5 marketable properties and then agree on who pays for what. Meanwhile, the building sat empty. Every month that passed with no resolution was costing the ownership group hundreds of thousands of dollars. In 2021, the majority owners had had enough. They filed suit. So what do you do when you're stuck in a TIC with no deadlock provisions and a partner who won't budge? In most states, any co-tenant in a tenancy-in-common has the right to petition a court to force a sale of the entire property. It's called a partition action. In January 2023, a New York Supreme Court judge sided with the majority owners and ordered a public auction of the Flatiron Building. The partition sale mechanisms actually gave the majority owners a structural advantage. They could credit their existing ownership stakes toward their bid, making them the natural frontrunners to buy out Silverstein's position and take full control. The auction itself became its own saga. An unknown bidder swooped in, won with a $190 million bid, and then vanished without paying his deposit. A second auction was held, and the majority owner group ultimately prevailed, finally gaining clean ownership of the entire building. All right, well, let's talk about what this all means. The situation is genuinely unusual. It's a combination of a legacy ownership structure, inherited ownership across generations, and a near total absence of contractual safeguards. That's a rare convergence. Most professional investors today would not walk into a deal structured this way. But the lessons are completely universal, and they apply whether you're a real estate investor or a business owner. Lesson 1. The most fundamental mistake in co-ownership in real estate and in business is creating an even voting power structure between partners. Even voting sounds fair on the surface. Equal partners, equal say. But the moment you have a disagreement, and in any long-term partnership, you have no path forward. You are legally stuck. Someone needs to hold the deciding vote. That can be structured in a lot of creative ways. A designated managing partner, a rotating tie-breaking mechanism, or a third-party arbitrator built into the agreement. But the structure itself has to contemplate the possibility of a deadlock, and it has to give you a way out. In the Flatiron situation, the TIC gave every owner, regardless of the percentage, an effective veto. 4 partners controlled 75% of the asset and still couldn't do anything without the 5th partner's agreement. That's a structural failure. Lesson 2. Now, sometimes an even split is the right business decision. Equal partners, equal skin in the game, equal upside. We understand that. But if you go that route, your agreement absolutely must have deadlock resolution provisions. This is non-negotiable from a contract drafting standpoint. A well-drafted co-ownership or operating agreement should address a few different scenarios. 1, a defined decision-making hierarchy. What requires unanimous consent versus majority vote versus managing partner authority? Could also do a buy-sell clause, often called a shotgun clause. When deadlocked, one partner can offer to buy the other out at a set price. The other must either sell at that price or buy at that price. Could also do, like we mentioned before, a mandatory mediation or arbitration. Could also do a right of first refusal if one partner wants to sell their stake. And you should, if there's heirs, clear succession planning provisions. What happens when an owner dies and their heirs inherit the stake? The Flatiron ownership had none of that. And in the absence of those provisions, the only legal remedy was a court-ordered sale of the entire asset, which is the most expensive and most disruptive action to take. Good contract drafting is not about being pessimistic about your partnership. It's about being realistic. Every business relationship has its season, and the agreement should be built to handle the end of that season without destroying the value of the asset in the process. Now, lesson 3. Let's talk about the TIC structure itself for a moment, because it's worth understanding why it exists and where it still shows up. A tenancy-in-common is rarely the preferred vehicle for professional real estate investment today. Most sophisticated investors use an LLC or a limited partnership structure. Structures that allow for majority rule governance, a clear management hierarchy, and operating agreements that contemplate every major scenario. But TICs do have a meaningful benefit that keeps them in play: 1031 exchange flexibility. Now, in a TIC, each owner holds a direct, undivided interest in the property, meaning each owner can independently sell their stake and roll the proceeds into a 1031 exchange, deferring capital gains tax. They don't need the other co-owner's consent to do so. However, in an LLC, the entity owns the property, so individual members typically can't do a 1031 exchange on their share without dissolving or structuring the entity. This is a meaningful tax planning advantage for TIC structures. So the TIC isn't without purpose, but when you have multiple owners with different visions for a property, especially over a long horizon, it is a headache. The governance limitations can paralyze decision-making in exactly the way we saw with the Flatiron. Modern TIC structures can be improved with written co-ownership or TIC agreements, building in majority vote thresholds, buyout rights, and dispute resolution mechanisms. But that requires intentional, competent drafting at the outset. The Flatiron's TIC was a legacy structure from 1945 that was never modernized. That's a cautionary tale for anyone inheriting or acquiring into a co-ownership structure. Understand the governance before you buy in. The Flatiron story ended with a court-ordered auction, years of costly litigation, and a building that sat vacant for a better part of 4 years while its owners fought. All that could have been avoided with a well-drafted co-ownership agreement at the outset, one that addressed decision-making authority, one that built in a path through disagreement, one that contemplated what happens when partners want different things. That's the work we do. In commercial real estate and in business law, the contracts that feel like paperwork at the beginning of a deal are the ones that protect you at the end of it. If you're entering into a partnership in real estate, in business, in any joint venture, make sure your agreement is built for the hard conversations, not just the easy ones. If you found this breakdown helpful or entertaining, subscribe. We do deep dives on commercial real estate and business law situations like this with practical takeaways you can actually use. And if you're looking at a deal right now where you have partners and you want to make sure your agreement is airtight, reach out. This is exactly what we help clients with.